Good evening and welcome to the Township of Chatham Township Committee meeting for May 25th, 2017. Greg, has adequate notice been given?
Yes, sir. Adequate notice of this meeting of the Township Committee was given as required by the Open Public Meetings Act as follows. Notice was given at both the Chatham Courier and the Morris County Daily Record on January 6, 2017. Notice was posted on the bulletin board in the main hallway of the municipal building on January 6, 2017. And notice was filed with the Township Clerk on January 6, 2017.
Thank you. Would you please stand for the flag salute?
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Maurer, he emailed me this afternoon that he's away on business. Mr. Kelly?
Here.
Mr. Sullivan?
Here.
Deputy Mayor Swartz?
Here.
Mayor Ritter?
Here. Do you have a motion to approve the agenda?
So moved.
All in favor?
Aye.
Second?
Second.
All in favor?
Aye.
Aye.
I move on to reports. You want to kick us off, Mike?
Nothing to report tonight, Mayor.
All right, thank you. Kevin?
Thank you, Mayor. I just wanted to report, as I had mentioned last meeting, Alice Lunt, who at the last meeting was sick in the hospital. She succumbed to her illness and passed away on May 15th. Certainly Alice left a lasting imprint on the town. She will not be forgotten. Her handprint is everywhere, including this chamber in which we sit. She was truly a remarkable woman, a fighter till the very end. She lived a life of strength and wisdom and wit, and a lady of grit and of grace. And so we'll miss her. The family is holding a memorial service on July 8th at Gloria Dei Lutheran Church at 11 a.m. for all her friends and all the people that the lives she's touched here in Chatham Township. That's it.
Thank you, Kevin. Karen?
Yes, thank you very much, Your Honor. First of all, our DPW is out getting ready for Memorial Day, even though it doesn't feel much like Memorial Day. The Colony Pool passed inspection, as did, all of the pools in the area have received inspection from our health department. So we're ready to go, and all we need is Mother Nature to cooperate. I've been told the Chatham Navy was out afloat in Colony putting the log roll in, and so far, all is good. Mother Nature has also helped with the water level, so it's all good to go. Let's see what else. We have mulch coming to all of our local playgrounds, and Castle Park, being the biggest one in the township, is actually going to have to close for a day while they do put the mulch in there. So if you do drive by with the kids hoping for a day at the park, it might actually be coming up that they'll be putting the new mulch in. We'll hear more about the paving schedule as we go forward with our new roads coming in, but our DPW will be out there ahead of the curve, pulling the manhole covers up an inch or two, and the basin grates as well. So it's an inconvenience, but at the end of the day, having freshly paved roads is going to be a real boon to our township. Christy Tragno, our fearless Christy Tragno, receptionist and jack of all trades at DPW, is also now our recycling coordinator. So anyone who has questions about recycling, she's going to try and fill Elaine's shoes, but she is going to be the one to take all the phone calls. Our Facebook page for Chatham Township Environmental Commission is live, and thanks to input from our communications department and patients on behalf of the Environmental Commission, Kara Fieser and her tireless work. So please go to Facebook and Chatham Township Environmental page and like it and follow it and share it and do all those great things. On a personal note, everybody, thank you for every single good wish that I received from all of you, phone calls and text messages and emails over the last several weeks while I was out of commission, to tap into Chatham for putting an article out there. I received some news about a physical issue through a regular annual checkup, and was therefore advised to have a surgical remedy. And, you know, we complain about Obamacare, or we love Obamacare, or whatever it is, but every health care plan in America covers annual checkups. So don't skip them. You never know. It could save your life. So Thanks for your patience and your kindness, and that's it.
Thank you, Karen, and it is great to have you back here, and I'm going for my physical next week. My report, just want to report on our opioid awareness presentation we held last night here in the municipal building here in this room with the Morris County Prosecutor's Office. We had a great turnout of folks who were there. It was videotaped. Tom's doing his magic, so we'll be editing that and sending it onto the website soon enough for people to watch in more detail at their convenience. Remind folks that the Colony Pool Club obviously is open for registration. I encourage everyone to go to thecolonypoolclub.org to register today. We said it's probably the best deal in the surrounding community as it relates to what you get, the value of your money and the amenities and the activities that are there. Also want to make mention, I know there's been some things reported in the press regarding parking at the train station and the committee's efforts. I think people should know that the committee has been active in this regard. It's not something that we take lightly. We are beholden to the borough as it relates to parking at the train station itself. If you're a township resident, if you're commuting to the city, you know you need to be there quite early to get a parking spot. If you're not, then unfortunately, you're on your own to find a spot. We have reached out to Uber in the past. Uber, as some folks know, piloted a program. I think, Mike, you had brought it up, maybe Bob Gallup had brought it up a while back, but Uber piloted a program in Summit. I had reached out to them to see if that's something we could incorporate in our town. Unfortunately, because we do not own the parking spots in the borough, it's not financially feasible, as we would have to subsidize the cost of it for our residents. That being said, there are a number of groups out there who offer opportunities for residents to park in the borough, one of which is called Boxcar App. Ironically enough, I was reached out by a friend, not a friend, I should say, a colleague, former classmate at Del Barton who actually started this group. Some people in town have come to me as well. They've heard about it. If you have an interest in learning more about it, you can go on your Apple phone or any phone, Android. It's Boxcar App. What they do is they work with local businesses in the borough, and basically you can go on there and reserve a spot for yourself. And in speaking with Joe, they have about 14 spots in the borough within about a quarter mile of the train station itself. They're looking to bring on another 10 or 20 on board in the subsequent week. They actually have an ad campaign launching this weekend in the borough, so people are going to learn about this soon enough. But I know people are always anxious to learn more about parking opportunities in the borough, and this is one such thing. It was also brought to my attention that, as you know, with the Jersey Transit announcing this past week that all trains on the Morris-Essex line, beginning I think July 7th, will now be going through Hoboken train station versus Midtown Direct. They're looking at offering bus service from Chatham and Summit as well. We know that Jersey Transit has done that similar thing in the past when there's been outages on the line, but since Jersey Transit has resolved the situation themselves by directing people through Hoboken, this could potentially be another opportunity for residents who want a one-seat ride. So that being said, I just want to make it clear that parking has always been an issue for the committee here and for township residents, and that we are always on top of this matter and do what we can to rectify the situation. We'll continue to look into this matter further in the future. With that, I'll turn it over to John.
Thank you, Mayor. Colony Pool, it's ready to be opened. And there are still a few more punch list items for the contractor to address, but we are ready to be opened. That's good news. The paving, still have not gotten a firm schedule from the contractor. I did put a schedule together, and I forwarded it to him and said, you know, I've been waiting for a schedule from you. Okay, here's the schedule we want. And so I forwarded that to him today. I told him I'd like to get an answer from him no later than tomorrow so that I can post the schedule so that this is our tentative schedule, because it would be approximately 2 weeks before the work starts. So I'm pushing to get the schedule posted on Friday. So at least it's a tentative schedule, weather permitting, and it also depends on production will vary from day to day, but you know, at least we can start getting that schedule up so people know how we're going to proceed. So pushing for that to happen. And just an update on our Safe Routes to School grants. We regarding Lafayette, we did recently obtain approval from the DOT that we have acceptable policies and procedures in place to receive federal funds. It only took a little while to get that approval. So the next step is the DOT is negotiating with the contractor, the consultant, to design the improvements, and it does appear based on recent correspondence that they are close to finalizing that scope and that fee. And then once that's finalized, then it will come to us to formally accept the proposal. The proposal it'd be obviously contingent upon DOT funding all the design fees. So, so hopefully within the next month, I'm hoping that we actually have have a consultant. At least it's brought to our attention. Okay.
John, does that mean it's possible the work would be done this summer, or
No.
is that still
No,
overly optimistic?
I think it's a very slow process, and I would expect that we may be talking in the possibly late fall, maybe early spring, that it would a project that we can discuss and talk then to once it's designed, once it's certified to be to go out to bid. There's a long bidding process. Realistically, I think it's more in the spring that we're likely to be talking about it and seeing if I, and then all of a sudden in the spring, does it make sense to postpone it to the summer just to kind of do it? So I think one step at a time. Frankly, I'm just been pushing the DOT to at least get the design consultant on board so they can start that work.
John, there has been a lot of public discourse surrounding this thing from start to finish. And I know that the folks who own properties along this proposed route are concerned about tree removal. And anybody who actually is an arborist at heart is concerned about tree removal. There are some substantial old oak trees and other old trees along the line, not to mention other design concerns. Will there be input from the public? Will there be discourse regarding the design? And the removal of trees, and whether you can negotiate around them or just remove them?
Absolutely. The one I made sure in their scope is to continue to offer residents the opportunity if we don't have sufficient right-of-way to go around some of the trees, we would need easements. So certainly if a property owner wants to convey an easement to us to go around the tree, I wanted that to be in their scope to entertain that. And I also made sure that there's availability for them to meet with the public, either a public hearing or meet in the field or just coordinate that. So, and I even specifically said to make sure that the time includes work on Saturdays so that we can meet residents on the weekend, so that more convenient to them.
And the corner property where the borough actually has half of the frontage of that house, we've coordinated with that homeowner, or are we still in the process of it?
I would say that we have gotten, we did have a survey completed of that last property to see what where one very large tree is located. And that tree is located in the township. So it is within a township right away, so that would be discussions around that tree. And again, that would be a perfect opportunity where if an easement was provided, we could certainly go right around that tree. And so that's something, again, to talk to the property owner about that.
When I think about the cooling costs that would be incurred at having that tree and not having the shade in that home, and I mean, it's a substantial tree cover.
Yeah, oh, absolutely. Absolutely. No, the goal was always to try to save as many trees as possible, and we knew that the right-of-way had limitations on how much room we had, and we always repeatedly conveyed that to the residents, that we would like to, we would jump at the opportunity to secure some easements to go around the trees.
Got it. Okay, thank you.
Anyone else? Thank you, John. Chief?
Mayor, just one thing, based on some forum postings and some inquiries about, once again, this time of the year soliciting, I figured it would be a good opportunity to go over the ordinance and answer some questions that you may have. First, let me go over the definition between a canvasser, a peddler, and a solicitor. canvassers distribute printed material or any other thing from house to house, or who calls in person upon the occupants of houses seeking contributions or anything of value. This is typically your environmental groups and religious organizations. A peddler offering for immediate sale, selling, and delivering the same to customers, or offering to render immediate services of any kind or description. This is typically your Girl Scouts selling cookies, ice cream trucks, or driveway sealers. Solicitors offer to sell goods, articles, or property of any kind or description by sample or otherwise for future delivery, or who offers to render services at some time in the future with or without accepting payment or partial payment for the same. This could be your home improvement companies or those seeking to provide financial services. So it's important, we always use the term solicitors. They're not all solicitors, they're not all doing the same thing. Here's the process. Those seeking to obtain a permit to partake in one of the previous mentioned activities must file application. Peddler applications and permits are handled through the town clerk's office. Canvasser and solicitor applications are handled through the police chief's office. But all applicants are required to have a background check conducted. This process is handled by the police department detectives. Although a permit may be requested by a specific company, it is actually granted to each agent of the company. If one agent of the company does not qualify for a permit upon the completion of his or her said background check, the company itself is not disqualified, and those remaining applicants who are cleared may receive the permit. Applicants for permits may be disqualified for such things as convictions for qualifying felony or misdemeanor crimes, dishonesty on the application, or any other information that becomes available that is not in the best interest of the public safety. So if someone in their background check perhaps is suspected of a crime, they'll be disqualified. To my knowledge, no permit has ever been denied based on the product or services to be offered or literature to be distributed. We don't pick and choose who we offer to give permits to. If they qualify, they're granted. After the permit has been granted, daily registration with the police department is required so that we know who is in town that day and where they will be. Permit holders are required to display the issued permits at all time and present them when requested. In most cases, they have the permit, it is displayed, they do process it, and we receive numerous phone calls anyway. Exemption to the permit rule, and this is important. I'm not going to read all the exemptions, but any member, officer, employee, agent, or representative of a religious, charitable, or political organization who is engaged in any door-to-door canvassing or soliciting on behalf of or for such organization and recognized as tax exempt under the United States IRS Code does not require to go through the permit process. What they are required to do is to register with us daily. So if they don't go through the permit process and they just give us a load of names, it is what it is. As far as religious and charitable organizations, as you may know, we have over the past few years successfully challenged and disqualified several organizations who have used one of those statuses in previous years. So for years and years and years, they all came under the same, either religious or charitable umbrella, for which we were able to disqualify them, disprove them in that matter. Here's the really important thing here, are the hours. The hours. And Albert will correct me if I'm wrong. No peddler, solicitor, or canvasser shall partake in such activity on Sundays or federal holidays. That's according to ordinance. Each permit holder shall be allowed to conduct such activity on weekdays and Saturdays from 9 to 5. Here's the one that gets everybody. Canvassers may engage in such activity from 9 a.m. to 9 p.m. on weekdays. And correct me if I'm wrong, it's either a state or a federal law. And it's been challenged. We were part of that challenge years ago where we were steadfast on 5 p.m. and we were challenged. And it is 9 o'clock. I know no one likes to have their door knocked on at 9 o'clock on a weeknight, but so is the case. At this time, there are only two companies that have permits to engage in soliciting or canvassing in Chatham Township at this time. And that is the Edward Jones Financial Group and Power Home Remodeling. That's it. I know there was an issue the other night with the magazine sales. Often they come over from the borough. They don't know where the boundaries are. They don't have permission to be here.
What was the second name that you read?
Power Home Remodeling.
Oh, okay.
So Chief, in those instances where someone gets a solicitor come to their door and they're not sure who they are, what they are, obviously they should ask for the permit.
Yeah, ask to see the permit. It should, if it's a legitimate permit that's applied or that is offered from us, then it should be displayed.
And if they don't have the permit on them, they should
Call us.
decline the services and
Call
call
us.
you.
Yeah, call us, because often we kick them back over the line. It's usually out of the borough. But again, you know, it's only 2 companies. You know, we have the Jehovah's Witnesses on occasions. We have these other charitable organizations that come, and we all know that the kids who sold the candy years ago, they were disqualified for a number of reasons. But, you know, that's pretty much the process. That's how it works. We don't
Right.
pick and choose who we allow to come into town. If they qualify on one way or the other, you know,
But you said the religious organizations don't need to file for a permit.
they don't need to file for a permit, but they need to register with us.
They need to
daily.
register with you, but what do they have to show that they have registered? Do they have documentation with them? Can I say,
In
show
most
me?
cases, at this point, we know who they are. We've already probably tried to disqualify them and couldn't. You know, again, you know, if we could just come with a blanket ordinance that says no soliciting, it would solve a lot of problems, but we don't pick and choose who we allow to come. You know, and again, the peddlers it goes through Greg's office, and that's more or less your ice cream truck type vendor, and essentially that comes through us, and those applicants are vetted, and then they're approved. You know, if any of these applicants can be disqualified, by all means, we would disqualify anyone that we could, but they all meet the standards that are required in order to receive the permit.
And when we talk to folks out there who have these concerns, one of the things we hear about is the belligerence when they get turned away. And I'm not saying that every person working for a charitable organization trying to sell magazine subscriptions handles rejection poorly, but there are some that do get belligerent. Would that be automatic disqualification? Would they be able to call you and say, have this guy removed from my neighborhood?
Absolutely. There are disqualifiers once the permit is received, and of course, that would be one of them.
I just want to report on one of the items that's actually on the agenda. I can do it when we get to it, or just preliminarily touch on it now. The bond ordinance that's on for your consideration to introduce would appropriate $105,000 that goes towards the Woodland Road sidewalk project from Treadwell down to Geralda Farms Park. What happened here is that we actually received a grant, you'll recall, for $138,000, which I think was actually in 2015, and we appropriated it in the budget. We did not go out to bid because of the problems with the State Transportation Trust program where the funds were coming from. So it got shelved for a while. The Transportation Trust now has been resolved, and John went out to bid a month or so ago. We received bids, and I think the low bid was like $240. So we had not provided for those additional funds in order to award the contract. Somehow between John and I, when we were communicating and putting together this year's road improvement program and the bond ordinance that was just adopted at the last meeting, we missed this. I'll take responsibility and say, I missed it. Just one of those things that kind of slipped through the crack momentarily. So we're asking to approve this bond ordinance, introduce it tonight, adopt it at the next meeting. That'll put us on track for being able to make the award sometime, I think, possibly the second meeting in June might be where we are, or the beginning of July. But until we do that, we don't have the sufficient funds to proceed with that project. So that's what that's about.
Tom, is that to extend, part of that is for the pavement on the shoulder? This isn't just the...
No, it
this
is
to...
But the 100 is not included. The paving within the shoulders, that would be available through the road resurfacing bond that we passed for the other roads. So there's sufficient money in that bond to cover that.
That's separate.
Well, that's a separate, it was more cost-effective to do the milling and paving under the Morris County Co-op contract versus putting this as part of the paving project. Because it would have been a sub, so instead of getting the markups, we just went direct.
And we tried to keep it also the funding within the scope of the grant application. So the project that was described is what we're doing.
John, could you refresh our memory on how that project is described? I mean, is it going to look like the existing walking trail around the perimeter of the Giralda?
It is, but it's not going to be as winding through the woods as the first half. And frankly, only because we have a substantial amount of wetlands within that area that kept us closer to the road. We also have the St. Hubert's section, and so that's a fairly large section of the paving where we're, again, just going right next to the road. So it's going to be characteristics. It's a 6-foot wide asphalt walkway, and it's going to be not as windy, but it's going to be continuous along the roadway.
But a little bit.
A little. We got a little bit in. We did. Towards the end.
Saving a few trees.
We did.
Tom, you want to say anything at the playground,
I'm sorry, about what?
the cell playground?
At Esternay? Well, we're moving forward with trying to get the temporary cell towers removed. As you know, there were temporary leases. They expired. We did direct T-Mobile to vacate the premises. They went to court, basically got a court order that allowed them to stay for an extended period of time, and we were obligated to file an application with Green Acres for a diversion to deal with the period of time that they've exceeded the original temporary approval. Part of the lease arrangement for Esternay Field, for where the tower was placed at the upper field, was for them to replace the playground with a new one. That playground was actually delivered yesterday, so it's now on site. You'll see there's a large container that is tucked away in the lower left-hand corner of the property, so that come October, which is when they're now going to be able to actually move on to the PSE&G tower, there's a 4 or 5 day window when the power grid will be shut down, and that's when they will move the antennas. At that time, they'll then take the temporary tower down and reinstall the playground. So it's moving along, but it's been a grind of a process. Albert and I had a lengthy meeting today with representatives from T-Mobile and from Green Acres about how we go about getting this all straightened out and resolved.
Great, thank you. And one thing for you, John, do we have a calendar yet return in terms of the paving in town this summer? Are we going to get a calendar in terms of?
A schedule?
Yeah, schedule.
Yes, yeah, absolutely. That's what I'm working with the contractor. That's what when I reported, the contractor just wasn't being responsive enough. I actually developed the calendar, the schedule for him to follow, and told him this is what you're going to do. And so I'm waiting for him to give me confirmation. And so I'm pushing him because I wanted to give a minimum of 2-week notice, at least have a tentative schedule. And it is tentative because we're on the schedule. The schedule could shift because there is time, we have weather permitting. Plenty of times where the work is scheduled, all of a sudden the town wants to pave a little bit, another town wants to pave a little bit more because the quantity came low and they just have a little extra money. Okay, now pave this road. Now it's knocked off a day. Mm-hmm. So it is a tentative schedule, and as we get, as part of the notification of the residents, once we have a firm date, we'll get hand notices out to all the residents and informing them to certainly contact me with any questions, monitor the webpage, and proceed. The work itself, we're basically doing, for the most part, a gutter mill where we cut the edge of the curb so we don't lose the curb reveal, and we're doing an overlay of the roadway in order to get a more pronounced crown, because right now the crowns are relatively flat, and we want to make sure that a proper road construction is to get the water off the center of the road, get it to the gutter line so that it can be captured. And so that's basically is a day's worth of work, or if anything, it's just the milling machine just passes the home. It doesn't, people can go around the milling machine. It's like it's blocking driveways. So we're not going to have road closures or anything associated with the milling. And then the day to paving is an inconvenience to the residents because it does limit their access in and out of the homes just for a short period of time. But it is a day. None of the roads are going to, every single road should be paved within one day. It's just we have so many roads, so you have multiple days. But it's really going to be an inconvenience that one day.
And what do you estimate the miles of roadway that'll be completed this summer?
I don't have that off the top of my head. It's about 11,000 tons of asphalt we're putting down.
Pretty significant.
It's very significant. It's very significant.
Can we mention the streets, and do you have a tentative sequencing?
Again, I want to get that blessed from the contract with that. But again,
But we know the streets we want to
Oh
do.
yeah, we know the streets.
Can we just announce them again?
I don't have the list in front of me, Tom.
Dale Drive,
Yeah.
right?
Yep.
Huron?
Yeah. I would have to get.
Okay.
All the roads that we're doing.
Greg could look it up, he can pop
Yeah,
up. You
we'll
don't
have it
have your
posted.
tablet tonight to look at the ordinance?
I don't want to miss anyone.
All right, we'll
and
come
then-
back
and
to
then-
it.
Good.
Yeah.
All right, thanks, John. All right, we'll now move on to a hearing of citizens. This is an opportunity for any member of the public to be heard about issues which are not topics scheduled for public hearing tonight. To help facilitate an orderly meeting and to permit all to be heard, speakers are asked to limit their comments to 3 minutes. Come on up to the mic, state your name and where you live.
Good evening. My name is Mike Nybert. I live at 41 Parkview Road, which is right off of Southern Boulevard, across from Corpus Christi Church and the Presbyterian Church. So the reason for my coming tonight is your animal control ordinance. There's a lot in there, a lot of regulation around dogs' behavior, particularly as it pertains to injuring a person, destroying personal property, including shrubs, trees, and things of that nature. It doesn't cover dogs attacking other dogs. My dog has been attacked 3 times by a rather aggressive German Shepherd living across the street. The first time it happened, there were no injuries, so trying to be good neighbors, we let it pass. The second time, my wife was about 3 steps out the front door to walk my dog, and they were both attacked. And because my wife was injured, I was able to go to court and file a complaint, and we went to mediation. There were some recommendations made about our neighbor putting up a fence and things of that nature, which they didn't. So back on May 7th of this year, my dog, while he was being walked on the street, was again attacked by the German Shepherd. This time it was pretty significant. My dog had to go to the vets on an emergency basis since it was a Sunday, and there were hundreds of dollars in expense, to treat his wounds. He's an older dog, so he really has a hard time defending himself. I just can only tell you that my neighbor is often careless and lets the dog, roam free in that yard. If he sees my dog, he will come after him. So I'm asking you tonight to consider, in the ordinance, to prohibit dogs from attacking other pets and inflicting injury. Now, my understanding is that there is a state law, and the animal control, which is contracted out through Milburn, will be looking into this case. But there's no guarantee that I'm going to be able to go back to court, or that there'll be sufficient evidence for a summons to be issued. What I really need is the ability to go back to court, take my neighbor there, and have a judge decide what needs to be done to keep this dog from attacking my animal or my pet. I mean, you'd be surprised how we have to juggle on a daily basis taking our dogs out. If they're out with their dog, I have to wait, and vice versa. And sometimes that works and sometimes it doesn't, because if they open their door and that dog shoots out, it's over.
Albert,
So-
Albert, are you familiar with the ordinance details and if it protects property, or if a dog were to attack property, would another dog could be considered property, or do you have to be explicit to say?
New Jersey regulates dogs quite extensively. Under Title IV of the state law, dogs are regulated quite extensively. From my understanding of the facts here, this is really an issue for the animal control officer. An animal control officer, if you have a vicious dog, can impound that dog. Through a municipal court proceeding, can have the dog euthanized if that's what the judge finds. So from my understanding, what I've heard here, it appears to me that the contact should be with the animal control officer, and perhaps advise the animal control officer at periods when the other dog is out, and have the animal control officer come and visit the site and see what is occurring. But what was described here, 3 attacks, is a vicious dog, or could be considered a vicious dog. And so I think the remedy here, certainly going forward, is to work with the municipally contracted animal control officer. I don't know whether amending your ordinance will fix this situation, because this is really a case where it's escalated beyond 2 neighbors. I'll be happy to look at the ordinance and see if there's something else that can be done, but if you want immediate relief, that's the person to contact. Any ordinance that you adopt can only be prospective.
May I make a comment?
It will not be able to address what's occurred before.
And the powers of the animal control officer, Albert? What
The
powers?
powers of the animal control officer are to enforce the vicious dog law
Of the state.
of the state.
There's your answer.
And it includes, and again, there must be observations or there must be a reliable evidence in order to present the case to the municipal court and prove. But the animal control officer can impound that dog until there's a hearing, or until the owner picks up the dog and makes some sort of an arrangement to avoid any other additional damage to either people or property.
And you're in touch with the animal control officers right now?
I am not.
You're not?
Okay.
All of our animal control calls go through the police department. The animal control officer does not answer calls from residents. He barely even answers my calls.
Yeah, we'll address that, but I thought you did say that the animal control was looking at this or not?
I understand.
You understand
from
that you have not
Detective
had direct
Anthony,
contact.
okay, I think that's his name, that the animal control officer was contacted. When they will contact me, or if they come out and do an investigation, I'm not sure when
Right.
and if that will happen.
I'll follow up on this tomorrow. Can I get your contact info before you go?
Absolutely.
Well, even just requiring your dog on a leash is part of our local protocol, right?
It is. Dogs are not allowed to run free. There's a number of violations here in what was described.
And again, you have to sort through them. Some of them exist already and can be cited for that reason.
And, in our day and age where everybody's got a video camera on their phone, you would hate to think that you would be videotaping an incident when your dog is in danger, but I wonder whether that would be substantial evidence, at least to present.
In my view, yes,
Yeah.
because you have a tape and you authenticate that you took that video and that's occurred on such and such a date and this is who was present, that kind of thing. So obviously a video can be properly authenticated. Albert, is the mic on? A video can be properly authenticated and accepted as evidence in any court.
I think the only issue I have is that this takes it out of my control in terms of being able to go to court. Now it's up to someone else. And since mediation did not work before, my interest is ensuring that my dog does not get attacked again. If my dog is out in the front yard with my grandkids, that, they are not attacked, then my wife, we're both in our 60s. And let me tell you, when you're taken down by a German Shepherd, you don't heal that fast. It's hard, and it's traumatizing. And I really think there needs to be a recourse, for the residents to be able to go to court. I was turned away this last time.
Well, I have to respectfully disagree. When the municipal prosecutor contacted the clerk, the municipal court clerk, they had no record of being contacted for this incident. And my understanding is that the municipal prosecutor spoke with the court clerk and the two deputies. So if you made a complaint,
I tried to make a complaint. I talked to the court administrator, Frank, and he told me that it has to go through with the animal control officer. That's the first I had heard of that. I wasn't even informed that there was an animal control officer until that point in time.
as I said, Mayor, I can certainly look at the ordinance to consider whether, or to determine whether or not that should be added to the ordinance, but the vicious dog law is really the key here. And there is an animal control officer. There's a procedure in place, and at least until that ordinance is amended, that's the procedure that should be followed.
Thank you, I appreciate your time.
Thank you for bringing this to our attention, though.
Mike, what were the provisions that were negotiated at the time it did go to court? And what is, and Albert, does that give us some avenue to proceed as well if something was agreed to and not done?
It's not, and when you say us, I'm not sure who you mean us is. This would have been between two private individuals, and if a court order was violated, there are remedies for that. So if whatever the mediation resulted, I assume there was some sort of agreement with the judge that it would be followed?
There was agreement with the mediator at that point, and then that report was then, as I understand it, passed on to the judge. So the recommendations were made to put up a fence, either an invisible fence or a physical fence, neither of which was done.
Have you gone back to court and said to the judge or the administrator, the mediation agreement is not being followed?
No.
That's even an earlier step. That's probably, and it's not my role to give you legal advice. I have enough trouble giving you legal advice to these folks. But I think if there's an agreement that was made as part of a court proceeding, and you believe it hasn't been followed, you go back to the municipal court. And that's an independent basis from anything else you've talked about.
Right.
Thank you, Mike.
Okay, thank you.
Appreciate it. Thank you. Would anyone else like to come forward? All right, moving on, we'll go to, we've got ordinance 2017-09, authorizing the acceptance of easements for a high gate at Chatham. So any discussion among the committee members before we open for public hearing? No. All right, we'll open it for hearing of citizens on this topic. Anyone want to come forward? See no one coming forward. Do I have a motion to?
Can you explain what it is?
John, why don't you do that?
Sure, it's there was a major subdivision within the township, and as part of the proceedings, as part of the planning board approval, there was a number of easements that were established that are ultimately conveyed to the township. It consists of steep slopes, some drainage easements. It's just a standard of care of part of the development of these properties, and in compliance with their planning board approval. It's part of that process.
And are there streets or roads behind me?
There were no necessarily new streets established. It was actually a subdivision which occurred within an existing paper road of the municipality, and basically this developer came in, developed the paper road, and the subdivision was part of some of the lots that were already fronting the paper road that existed.
Can you just share?
If you can come forward and show you.
Please step to the microphone, give your name and your address.
Arlene Driscoll, 145 Terrace Drive. So I'm just curious as to where in Chatham Township this is.
Mountain View. There off of River Road, you go up Mountain View, and then it's within that area.
Okay, all right, thank you.
Just
before you get to Township, if you turn up Henry Drive and people
Okay, thank you.
And this is not unusual. This is a typical event that occurs as a development is being closed out. Certain certain things were required by the planning board to be constructed by the developer. And now it's time to grant easements to those improvements to the municipality.
Okay, thank you for the explanation.
Is there a motion to approve?
So moved.
Is there a second?
Second.
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
Yes.
Mayor Ritter?
Yes. We're introducing two ordinances tonight. First one is ordinance 2017-10. It's the bond ordinance that Tom had referenced earlier. Any discussion among the committee?
I think I'm square on it.
Square? Public hearing on this? No, you just introduced? All right. Motion to approve, or motion to introduce?
So moved.
Second?
Second.
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
Yes.
Mayor Ritter?
Yes. Second
And
ordinance?
if all four of you plan to be here at our June 8th meeting, then we can put it on for public hearing at that night?
Very good.
I'm not going anywhere.
Should be here. Next is ordinance 2017-11, amending zoning designation for block 144, lot 33. John, would you mind just giving some color on that?
Picture says 1,000 words.
Thanks, sir.
Thank you.
We did receive a request from the Oak Knoll Schools to rezone their property, and basically they have 3 zones that currently make up their property. Their property is approximately 13.5 acres, and presently a part of it is in the R2 zone, part of it is in the R5 zone, and a portion of it is in the PI2 zone, which is a professional institutional zone. Back in 2001, they applied to the planning board for a conditional use to develop the property to the fields that are there today. Institutional uses are permitted in the R2 and R5 zone. And in 2001, ultimately there was an oversight. The application was submitted to the planning board, and it did not identify the PI2 zone in that application. And the complication is that the professional institution zone does not allow institutional uses. I'm sorry, it's the PI2 zone. The PI1 zone does, but the PI2 doesn't. So it only allows it as a conditional use. So, so ultimately, the Oak Knoll did come to the planning board to amend their conditional use that they obtained in 2013 to convert one of their natural turf fields to artificial turf. It started in the process of going to the planning board, and ultimately it did come out that it's 3 zones on the property, not 2, and so they do have a use that's been constructed that is not consistent with the current zoning regulations. And so the request has been made to convert the property, eliminate the R5 zone, which is solely on the Oak Knoll property, eliminate a piece of the PI2 zone on the Oak Knoll property, and convert it completely to the R2 zone. And it's a reasonable request. Frankly, the portion in the PI2 zone, majority of that property is in fact a wetlands that's been deed restricted, so there's really nothing you can develop in that small portion anyway. So converting that to the R2 makes sense. And then the R5, the most significant difference between the R2 and the R5, R5 is basically 1 acre zoning, R2 is approximately 1.5 acre zoning. The R2 allows cluster zoning to 1 acre, and so the Oak Knoll has made no representation of changing the use and redeveloping it for residential purposes, but in 20 years, if they wanted to. The R2 zone also allows for cluster zoning for 1 acre lots, and so that's probably how they would develop this anyway because of the wetlands and constraints. So making these zone changes really has no impact on in a practical sense because the portion, as I stated before, the portion of the PI2 zone, it's already restricted with wetlands, and the practicality of R2 and R5 is really no difference in how that would be developed. And the majority of the areas you can see on the aerial photograph, the majority surrounding the fields is R2 existing. So they're really just so basically the request is to rezone their property, so it just is basically one zone, the R2 zone.
But the request is to rezone a very specific piece of property, block 144, lot 33.
Correct, which is their entire lot.
Okay.
Because their lot did consist of 5 individual lots at that, when they applied for it in 2001, but as part of the conditional approval of 2003, they did have to consolidate the lots. So all the lots were consolidated, so it is one lot right now that's being rezoned. It only affects the Oak Knoll property, and it's basically just addressing as I discussed.
And it's one lot that's spread across 3 zones.
Correct.
And so it's that where the split zone occurs is being allocated to the R2, which encompasses the rest of the lot.
Correct.
And John, this is coming to us with a recommendation of the planning board that we do this?
No, the procedure is it's come here first, and then you would forward it to the planning board. The planning board already has it on their agenda for June 5th, so it's already discussions of that this is coming. So it's the applicant, as I indicated, the application was already scheduled to be heard with the planning board, and so the planning board members already have it, and they were informed of what we discovered with the PI2 zone, which kind of put their application on hold. So we're rectifying the application. So it is in front of the appropriate board, as in front of the planning board, because otherwise they would have to go to the Board of Adjustment for a use variance.
So before this ordinance comes back to us for final vote, we'll have the input from the planning board?
Correct.
Yes.
Correct.
Okay.
Yeah, the planning board attorney has been involved in discussions on trying to figure out the cleanest way to fix this. It's a little bit embarrassing, frankly, that 16 years ago we missed it. It should not have ever happened this way.
Any questions?
Regarding the PI2 zone, that's going to become part of the R2 as well?
No, where you see the, let me.
Because I see where they're institutional use here, I got
This
that.
stays the same. This piece of the PI2, which is part of Oak Knoll, this gets converted to R2.
Okay.
And it houses, I think it's the detention basin, so nothing else, and it's deed restricted. So you'll see there's marsh grass.
Yeah,
This stays the same.
it does, but this PI2
Stays the
zoning
same.
allows for businesses, you're saying?
It allows for the use that's there.
Oh, okay, great. I must have misheard something there, thanks.
Any other questions? There's a motion to introduce.
So moved.
Is there a second?
Second?
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
Yes.
Mayor Ritter?
Yes.
And since the planning board plans to deal with this on June 5th, we can have public hearing on June 8th.
Albert, we have these resolutions. Now that John's not here tonight, can we move that one resolution to the consent? Or,
Well, my own suggestion is leave it there because I was planning on giving an explanation,
fair enough?
and
All right.
I can do that if that's your pleasure.
Sure, let's give it a go. So we got Resolution 2017-108, authorizing settlement agreement with Vernon Grove. Albert, you want to give us some color?
Yes. This involves the extension of affordability controls at the Vernon Grove condominium. The Vernon Grove condominium has been a part of the township's affordable housing plan for at least 10 years. Vernon Grove is an existing affordable housing development on River Road in the township with 72 units and has existed since 1986. The original affordability controls were for 30 years. Those controls expired in the fall of 2016. Prior to the affordability controls expiring, the township adopted resolutions and recorded a restriction extending those affordability controls for an additional 30-year period. The condominium association and several unit owners objected to that, and as you know, the town's plan, affordable housing plan, is pending before the Superior Court as part of a declaratory judgment action. So the homeowners, in essence, filed an objection with the Superior Court. This settlement agreement provides a mechanism for the controls to be extended by the unit owners, and if the extensions provide that the township will make a capital contribution or deferred maintenance charge contribution to the condominium. There is an initial payment of $16,000 for parking lot paving and an annual payment of $29,000 for each of 30 years while the new controls continue to exist. The settlement agreement memorializes the mechanism to extend the controls, the payment mechanisms, and provides that it is subject to approval by the condominium association, the unit owners, and the Superior Court of New Jersey. The settlement agreement requires approval by the Superior Court because, as I said, this is a part of the town's affordable housing plan, and which has been a part of the affordable housing plan since at least 10 years ago. This settlement agreement meets two municipal purposes. The first purpose is to continue to provide affordable housing in the township, and the township is doing so at an existing site. And it also allows a mechanism for the association to maintain its infrastructure and its plant. And the first capital improvement that would be made is a repaving of that parking lot. And then each year, the association, as part of the capital budget that it adopts, much like you, would identify those items that the association intends to expend funds that year. Once the association adopts that budget, that capital budget, the town would pay its $29,000 annually. And there are checks and balances within the agreement allowing the township to monitor the expenditure of those funds to ensure that they're expended on a capital improvement or capital maintenance. As I said, this is part of the plan. It's a part, as you know, the other parts of the plan are still being litigated and the subject of settlement discussions. So I can't deal with those issues right now, and I would suggest that you also not deal with them. But in terms of this settlement agreement, it would be a public document. The settlement agreement would be a public document. It will be have to be signed by the association, and the agreement provides for a mechanism for both parties to move forward.
Okay, great. Well, Albert, I just want to commend you. I know people ask, what are we doing affordable housing-wise for the past year and change and so, and this has been a component of it, and you've done yeoman's work on this, so I commend you for your efforts and keeping us posted on how things have gone, and I think it's an important step. So thank you for that, and Tom as well for all that you've done as well. So.
Well, thank you, and it's been a cooperative effort with the association. As you remember, when the controls were extended, several residents came and spoke about extending those controls, and one of the things that they discussed was the need for infrastructure improvements there, and that became a vehicle for trying to resolve this component of the affordable housing plan of the town. So it really has been a very cooperative effort by the administration, by the association, and looking forward to going through the process and presenting it to the Superior Court for approval, which this doesn't become final until approved by the Superior Court. Okay.
Mayor, just, again, understanding that this isn't a done deal until it's approved by the courts and I guess finally approved by the property owners as well, but this is big news. I mean, 72 units to preserve them as affordable housing, and this is part of what we've been grappling with in closed session for over a year. So the public, to the extent that they've been asking, hey, what's going on, and when are we going to hear about it? This is a portion of it. It's not the whole picture, because a lot of that is still in negotiations, but I mean, this is a key progress on a key part of it. So thank you for shepherding it through, and happy that we can now finally talk about it.
Any other comments, questions? I have a motion to approve?
So moved.
Is there a second?
Second.
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
Yes.
Mayor Ritter?
Yes. Consent agenda. Greg, would you mind reading those off for us?
This evening, we have Resolution 2017-109, receipt of reports, 2017-110, approving meeting minutes, 2017-111, approving executive session minutes, 2017-112, refunding tax lien, and 2017-113, renewal of liquor license.
Any questions, comments on the consent agenda?
I do, having missed the meeting regarding the minutes, both the executive session and regular meeting minutes, do I abstain from those two?
Yes.
Is there a motion to approve?
Well, I would just like to mention, Greg, you didn't mention the fact that I pointed out to the school budget, the differential, and Ed wouldn't report on it because he lives in the borough, but the differential that we're paying from a standpoint of the differential between the tax base here and the tax base in the borough, and the fact that we have 48% of the student body and are paying an extra $6 million a year. So I don't know if you...
Are you making a motion to amend?
I'm not making a motion. I just wanted to embarrass Ed here in the meeting. So, but no, that's fine.
Ed's not
Well,
the
that
least
was-
bit embarrassed by that.
That'll certainly be reflected in these minutes.
Any other comments on the consent agenda? Is there a motion to approve?
So moved.
Is there a second?
Second.
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
With the aforementioned abstentions, yes.
And Mayor Ritter?
Yes. We'll now open up for another hearing of citizens.
Mayor, before you do, can I just comment on one of the resolutions that you just approved? The refunding of the tax lien was for a property, there was a property tax lien on a property down on River Road, down in the 800 block. All the neighbors are quite familiar with it. It's been an eyesore for a number of years. The owner had fallen on some difficult times and it fell into delinquency. It recently was foreclosed upon. The lien holder actually had started foreclosure proceedings. He subsequently has had the lien redeemed, which is why we're doing the refund tonight. But the home now is under new ownership, and we'll be communicating with them in the very near future about their plans to rehabilitate the property. So hopefully there's a light at the end of the tunnel here for the neighborhood to see that property get cleaned up.
Great. Thank you, Tom. Open up for hearing of citizens. Anyone like to come forward? Seeing no one come forward, we're going to take a resolution for the executive session. Greg, would you mind reading that?
Resolution 2017-P-08, resolution of the Township Committee of the Township of Chatham in the County of Morris, New Jersey, authorizing conference of the Township Committee with public excluded. Whereas NJSA 10:4-12 of the Open Public Meetings Act permits the exclusion of the public from a meeting in certain circumstances. And whereas the Township Committee of the Township of Chatham is of the opinion that such circumstances presently exist, now therefore be it resolved by the Township Committee of the Township of Chatham, County of Morris, State of New Jersey as follows. The public shall be excluded from discussion of the specified subject matter. The general nature of the subject matter to be discussed is as follows. Litigation in the matter of the Township of Chatham for judgment of compliance of its third round housing element and fair share plan, docket number MRS-L-1659-15, and B, property acquisition, open space. It is anticipated that the minutes on the subject matter of the executive session will be made public upon conclusion of the matter under discussion and in any event when appropriate pursuant to NJSA 10:4-7 and 4-13. The committee will come back into regular session and may take further action. This resolution shall take effect immediately.
Motion to approve.
So moved.
For second?
Second?
Mr. Kelly?
Yes.
Mr. Sullivan?
Yes.
Deputy Mayor Schwartz?
Yes.
Mayor Ritter?
Yes.